morning. Welcome to the second installment of Miller Johnson's Workplace Wednesdays webinar series. I'm Keith Eastland. I'm going to be talking with you along with my friend and partner, Patrick Edzinga, and in our second installment of this series. And by the way, the series, remember, is designed to take a look at all of the legal changes, principally beginning with labor law changes that we're going to see as part of the new Biden administration, and to make sure that you guys are ready for those. You've taken steps in advance so that you're prepared, and that so you're not playing catch up. It's a really important series, and we're glad you're with us. And the second installment, by the way, the first installment was last Wednesday. If you couldn't join us, it is available for some overall background, and you can listen to that at your leisure. It's available through our website. But on our second installment, we want to talk about changes to union organizing, and specifically the PRO Act, which we're going to spend most of the day or this morning talking about. Obviously, we have clients on the call. We have some non-clients. This is not legal advice, and it doesn't establish a client relationship. I think you guys understand that. And then we have some upcoming webinars there. So next week will be part 2 of the PRO Act discussion, followed by what happens if you were unfortunate enough to lose an NLRB election and become unionized. Okay, thanks, Patrick. Let's talk about today's focus. So what are we going to cover? We're going to cover the Protecting the Right to Organize Act, talk a little bit about how we got here, the purpose of the Act, and then we're going to get into some of the specific provisions of the PRO Act. And there's something here for both union and non-union employers. So I think as we go through those specific provisions, you'll kind of see how the PRO Act seeks to achieve the purposes that it's being advanced for. And because there are so many of these changes, we're going to do this in 2 parts. Next week's session will cover additional specific provisions. Okay, how did we get here? Well, some of you may remember about 12 years ago, there was this thing called the Employee Free Choice Act. And there was significant alarm in the employer community. The centerpiece of that proposed legislation, which was advanced by organized labor, was what they called card check, right? Everybody was very nervous that the unions were going to get able to get 50% of your employees to sign union authorization cards, and then you would be required to recognize the union without even having a secret ballot election. So you're going to cut the election out of the process. And another part of that Employee Free Choice Act was significant increases in financial penalties to make it hurt if the employer were to engage in any unlawful conduct, financially painful. And so, that didn't pass. It sort of stalled out. And so people are saying, well, isn't this just the Employee Free Choice Act all over again? Really, Keith, are you telling me the PRO Act is going to be any different? What's different this time around? Well, I would say 2 words in response to that question. A lot has changed. The landscape has changed, both socially, right? The background, it's a different world than it was 12 years ago, as well as legally, right? We all seen last summer the increased focus need for change, the protests regarding racial inequality. I mean, the COVID-19 pandemic. We watched the election results. We know that it's a 50-50 Senate, and the Democratic Party has control of the House of Representatives. And we know, if we're reading anything in the news, President Biden said he's going to be the most pro-union president that ever was. Okay. Last week, he had a meeting with the 10 top union leaders, national leaders, where they talked about things, including the PRO Act. This is something that's important to President Biden, and it's going to happen. Now, its final form may be a little different. We'll talk about that later. But it's coming, and you need to be ready for it. Okay? We all know about the summer protests. We saw them. We saw them here in Grand Rapids. And what I think is important to draw from that is, it's a change in the landscape, And what we saw among the common citizen, among your employees, right, is this momentum for standing together, right? Obviously, you can rally around these causes that are easy to rally around, right? Racial inequity, yes, absolutely. But there's this sense of collectivism that is building, this momentum that is building among a lot of people in our country. And what are the unions doing about that? They're looking to capitalize on that momentum. Take a look at some of these tweets from February 13th, the International Union of Painters and Allied Trades, talking about right to work, originated in the 1940s as a way to maintain Jim Crow in the South, right? We need the PRO Act to rid ourselves of Jim Crow. That's what the union says. Jeff Stein, a Washington Post reporter, right? This is that meeting I was talking about last Wednesday, February 17th. Labor leaders were pressing the president to pass the PRO Act. Quote, a union card is the single best tool we have to advance racial justice and gender equity on the job. So the union is equating itself with the need to fix racial injustice. If you're against the union, you're against racial justice. If you're against the union, you're against gender equity. We all know that's not necessarily true, but that's how that's how the unions are seeking to capitalize on this momentum. And then Washington Senator Patty Murray, the PRO Act is not just a labor issue, it's an equity issue. So you can see how the unions are going to rally around the unrest. And then, of course, we have the COVID-19 pandemic, right? What has COVID-19 done to many workplaces, maybe yours, right? It's isolated people, right? It's been frustrating. It's been difficult on people. People are stressed. They're worried. They're worried about their family. They're worried about their jobs, right? Normal problems become big problems, right? People are in isolation. They don't hear from their boss. Maybe they're working remotely, or maybe the boss isn't on work site. The supervisor, foreman's not around, or maybe they feel stressed because they have to be working. But all of these angst that COVID represents, right? The unions are looking to capitalize on that too, right? A lot of the frontline workers, grocery workers we see in Amazon, right? Bessemer, Alabama, if you're following the news. They're going to have a mail ballot election for 6,000 workers to see if they want to unionize at the Amazon's warehouse in Alabama. That's the first time that there's been a significant organizing drive at Amazon. There was one out east maybe 18 months ago that faltered pretty quickly. But this is the real deal. And with the mail ballots, you probably saw Amazon's fighting really hard, right? Because right now with COVID, the NLRB elections for union selection are all being done via the mail. Okay. And again, we see this, right? We see this in social media in the tweets. Again, Senator Murray, she's saying that workers during this pandemic to build back the economy that works for everyone, right? We need this PRO Act, because of it's tied to infrastructure spending, according to Richard Trumka, the AFL-CIO head, right? This PRO Act, according to Representative Dan Kildee, right, who's Michigan rep, District 5 out of Flint, right? This is tied to COVID. Like, we need this as part of our COVID relief package. Well, everyone agrees with COVID relief, so why not tie the PRO Act to that, tie other things to that? I read this morning, it looks like there's going to be a $65 million bailout for union pension funds as part of this, and that may pass. Why does that matter? Because think about that from a union organizing tool. Many people think, well, why would you want to be part of a union when you're paying whatever, $7, $8, $9 an hour into a pension fund and you're never going to get anything out of it? That's all gone. That's all saved by the government, by the taxpayer, if you will, if this gets passed. So you can see kind of how the unions are going to use these things. Go ahead, next slide. Okay. I now want to turn it over to Patrick. He's going to talk a little bit about the purpose of the act before we dig into some of the detailed provision.
Thanks, Keith, and good morning, everyone. So after talking through how we got here and why this time certainly could be different, I think it's important to also talk about what is the purpose underlying this act. And so we see it's the Protecting the Rights to Organize Act, right? That's the title. That makes it seem like it's innocuous enough. protecting employees' rights to organize. Who doesn't agree with that? Sure, even I agree with that. That's fine. That is not what this is. It is about much, much more than protecting employees' rights to organize. If we were going to accurately title it, we might call it increasing the rights to organize, or enhancing the rights to organize, or putting the rights to organize on steroids. Something like that would be more accurate, because this is about more than just protecting those rights. It's about greatly expanding those rights. And nobody's really hiding it. They're all very clear on the purpose of this, which is to make it easier for unions to organize in your workplace, for employees to engage in protected activity in your workplace, and ultimately to transfer wealth from corporations to employees through the collective bargaining process. Like I said, it's not a secret. Nobody is hiding the fact that this is the goal. The AFL-CIO, which is the largest federation of unions in the United States, it is made up of 55 unions, and it represents over 12 million active and retired employees. Their president, Richard Trumka, said on January 14th in a Facebook town hall entitled Fight for the PRO Act, in which there were lawmakers from both the House and the Senate there, a bunch of other union leaders there. He laid it all out in his keynote address, and I'll just give you a few quotes from that. I didn't watch the Facebook Live feed, but I read the transcript. He called the PRO Act a total game changer and a cornerstone of their workers' first agenda. He said, right now is a generational opportunity for organized labor. He said that when they make the PRO Act law, we will need to print millions of new union cards. And then this one is the kicker to me. He said, it is time to change the power dynamics in America. This, meaning the PRO Act, is how we do it. So as I said, nobody is hiding the fact that this is the goal here. And the union leadership has also made it very, very clear that they expect the PRO Act to be passed and signed into law. Again, Richard Trumka said as much. Following the reintroduction of the PRO Act into Congress on February 4, this is what he said in his press release. The PRO Act will strengthen workers' ability to come together and demand a fair share of the wealth we create, boosting wages, securing better health care, and rooting out discrimination. And then at the end, he puts the pressure on. He says, make no mistakes, this is a test for Democrats. After decades of disappointment, it is time for the party of FDR to finish what he started. So they've been very, very clear with Democrats, you need to get this done. And the Democrats are listening. So this is candidate Biden and President Biden. He's been very clear all along. This is what he will do if he has the opportunity. He'll sign the PRO Act into law. You can see at the bottom there's his quote about being the strongest labor president workers have ever had. But I think these tweets are also telling, because it makes very clear that he's on board with this. He'll sign the PRO Act, which makes it easier for workers to organize and collectively bargain. And then when he becomes president, the day that the PRO Act is reintroduced into Congress, he tweets this out. Says that it is the policy of our government to encourage union organizing and to ensure that employers give their workers a free and fair choice to join a union. So the Democratic Party is listening at the very top. It is also listening in the Senate and in the House. I mean, I was looking at these tweets, I could have put 50 of them up. They're all over the place. The Democratic Party is supporting the PRO Act, and I think there's a political reason for doing it, right? There was sort of, for years and years and years, Democrats could rely on unions and organized labor to be a part of their base. That changed in 2016. And they worked hard in 2020 to make sure it didn't happen again. And they're working hard going forward to make sure that the union members and organized labor at the top remains part of its base, part of its donors. And so they're paying attention. They're going to be pushing for this. The unions know that some of them will be looking for a way out of this, and that the pressure will be intense. And so Richard Trumka in that same Facebook Live address said, we're going to be in every district. We're going to be in every state. We're going to be pushing to pass this, because they know they need to keep the pressure on for this to happen. So far anyway, they are paying attention. at the top, in the House, in the Senate, and we'll need to, take that seriously. Okay, so that's the purpose. We talked about how we got here and what might be different. Now let's talk about the changes that are in the PRO Act, the specifics, because I'm sure you all are keenly interested in this. And as Keith said, there are so many of them that we'll need to break this up into two parts. So this is part one, and we sort of just worked chronologically through the act as we read it. So these are the changes at the top, and then next week we'll discuss the additional changes. But before we do that, let's talk about where does the PRO Act stand. So you probably have heard of the PRO Act before. It was introduced into Congress in the fall of 2019. Not this exact version that's been reintroduced, but a version very, very similar to this was introduced in the fall of 2019. It passed the House of Representatives in February of 2020, pretty much on a strictly party line vote. It made its way over to the Senate. It was put into committee. It never made its way out of committee. And the reason, in large part, is that the Republicans controlled the committees at that time. And so it never got pushed out of committee. It never received a vote on the Senate floor. It more or less just stalled out. So now, new Congress, new president in the White House. In just 20 days ago, it was reintroduced into Congress, and it will be on the floor of the House. It'll be in the Senate. It's in committee right now, but we certainly expect it to come out of committee. The Senate is going to be where all the action is here. The House already passed it once, so it's expected to pass it again, although the Democratic Party does have a narrower majority in the House of Representatives, but the action is going to be in the Senate. And the big question on what the final version of the PRO Act looks like and whether it passes is going to be whether the Senate retains the filibuster. As of right now, the Senate has indicated that it will retain the filibuster, but that is certainly a fluid situation. And if the filibuster went away, then we need to pay even more attention to this because the filibuster requires 60 votes for it to pass. And right now there are 50 Democrats in the Senate and 50 Republicans. So 10 Republicans and all the Democrats would need to sign off on this for it to make it to the president's desk, unless the filibuster is removed or they find some other creative way to get around it. Okay, with that introduction to where it stands, I'm going to turn it back over to Keith, and he's going to talk to you about the specifics of what the PRO Act does.
Thanks, Patrick. So how does it tip the scales, right? How does the PRO Act really do this? Well, we've listed out three categories, and I think when you look at each provision of the Act, it fits into one of these three categories. One is expanding union and employee rights to organize and bargain, strengthening those. Two, restricting the employer rights to oppose unionization or your rights to bargain if you're a unionized employer. Again, this is like organized labor's wish list, everything that they want that will impact both union and non-union employers. And then the third category is silencing employers' voices through expansion of the scope, by expanding the scope of the action that violates the law. So what you currently do that's lawful may become unlawful, excluding employers from important election procedures, and through increased penalties and expanded remedial provisions that we'll talk about in detail next week. All right, so the first change I want to talk about is expanding the definition of employees. Under the PRO Act, employees, and remember this is important because employees are the ones who have Section 7 rights under the National Labor Relations Act. They're the ones that you can't discriminate against because of union activity, and they're the ones that have the right to organize you, okay? And so now that includes any individual performing any service for you under the PRO Act. That would be the expansion, okay? And what this is really tied to is, look, you may have independent contractors that you work with or you hire in, but if they're performing any service for your business, and we'll have to litigate the scope of that, but you can imagine that's pretty broad, they're not going to be independent contractors. And the test for independent contractors under the new legislation will be the one that has been adopted in California. and it's the burden's going to be on the employers if you're going to say, well, this group's not eligible to unionize because they're not employees, they're independent contractors. You're going to have to show they're free from control and direction in the performance of the service, right? So you don't control them. You don't have the right to control these people, and you don't control these people. And the service is performed outside the usual course of business. So if you have independent contractors that are doing something that's, consistent with your principal activities for your business or your operations, they can't be independent contractors under this new law. And so that's pretty scary. And then the third factor is the individual also has to be engaged independently, right? So you can't have captive independent contractors anymore. Okay? So you can see the idea is we want lots and lots of people to have the right to sign union cards, join unions, make lots and lots of employers bargain with them. Okay. The next thing that the PRO Act does is it changes the definition of supervisor under the Act. And what it does is it really constricts who's a supervisor. Right now, if you spend time performing one of a number of job functions, supervisory in nature, such as the right to hire, fire, issue discipline, responsibly direct, assign work and be held accountable, those sorts of things, you can become a supervisor. That changes. The assignment, the responsibility to direct workers, that comes out. And what gets added is a requirement that the individual performing those supervisory functions, hiring, firing, disciplining, that sort of thing, the traditional supervisory indicia, if you will, you must do those for the majority of your time. So think about your leads on a production line. Think about your construction team leads or foremen, working foremen, those sorts of positions. They're going to have rights to unionize. They're not going to be a supervisor anymore. Now, that can cut both ways. That may be good for some people because you may think, great, because they don't want a union, but it is an expansion of the number of individuals who will have these rights. Okay. This next first bullet point on this slide, guys, is a huge one. Okay, what the PRO Act would do, right? So in a typical organizing drive or an employer learns about union card signing, if you've been through this, you know how it works. If you haven't, one of the things you want to do is establish lines of communication and explain your side of the story and why this isn't such a good idea, right? You want to be able to talk to your employees, bring them in, explain what a union card is, why they should think twice and make darn sure that that's what they want to sign up for, give them those facts. Well, a lot of times you do that through meetings, right? You have departmental meetings, you have floor meetings, however your organization is structured, and you get the right individuals, leadership, to talk to these folks to make sure that those open lines of communication are there. Okay. Under the PRO Act, it would be unlawful for you to have any required meetings or communications with the employees for that purpose, unless it's absolutely 100% related to their job duties. So no more mandatory meetings, no more, hey, we can talk about this in the mandatory department meetings. If you want to talk about anything related to union organizing, it's completely voluntary. Employees can walk away. And if they feel coerced or feel required, you will have violated the law. And as we're going to talk about next week, that's going to have significant financial penalties. So my job as a labor lawyer, Patrick and I's job, Miller Johnson's job as labor lawyers, is going to get a whole lot more important, because now we got to figure out and make sure that we're not having a meeting that you're violating the law that you're going to get fined thousands of dollars for, just because you want to exercise your First Amendment rights, your previous statutory rights they exist now, but your statutory rights to speak freely. That's right. You can't talk to them. You can't make them listen. They work for you, but you're not allowed to make them listen. That, to me, is very, very significant. That would change how organizing drives and the ability of employers to communicate all of the facts to their employees. It really puts a muzzle on the employer. Okay, the next 2 points I'll talk about quickly. They are mostly for unionized employers, but the PRO Act would redefine what it means to have a duty to bargain, okay? And if you're a current, right now, if you're a unionized employer, your contract expires, you want to make changes, the union says, no, you can reach an impasse in your negotiations, and then you have the right to make the changes unilaterally if you're at a legitimate impasse. That would change under the PRO Act. You must maintain the current status quo of the contract. Even if you need changes, you got to keep those changes in place unless and until the union agrees or they're thrown out. Big change. The next one is they want to eliminate permanent replacements. Right now, when employees don't have a contract, they can go on strike for economics to get better wages and benefits. If the purpose of the strike is economic, you have the right to replace them, right? And employers use this in organizing campaigns too, because you get to tell people, look, if you follow the union out on strike, you can be permanently replaced, which means you're not fired, but what it means is we hire someone else to take your job, and you get in line, you stand on the sideline until that person leaves, till there's an opening. So if Patrick gets permanently displaced by Keith, and Keith stays there for 6 months, guess what, Patrick? You don't have a job for 6 months, even if you want to come back to work. Right? That's a significant, weapon, economic weapon that the employer would have that would be gone. And same thing for lockouts. Employers would only be able to lock out employees if there was first a strike. So you can't just lock out to gain concessions. And the last point on this slide, guys, is if you are unionized and a majority of your employees sign a petition that says, hey, we don't want to be part of the union, we don't want the union to represent us anymore. If you had over half of the bargaining unit or the bargaining group present that to you, the employer right now has the right to say, okay, we're at certain times, we no longer will represent you. We will no longer recognize the union as your representative. You can tell the union that if it's an appropriate window, and it's done. Now the employer no longer has the ability to do that. Now there has to be a decertification election under the PRO Act, if it gets passed, when it gets passed, I should say. All right, next slide. All right, this is my last slide, and these are some really big ones, right? Purple Communications Revenge. If you've been on Miller Johnson's webinars or any of our workshops or client seminars, you've heard about Purple Communications, right? That's the NLRB case that had, under the Obama board, that had held that your property really isn't your property. Your email systems, your cell phones, those sorts of things, if you allow your employees to use them or require them to use them in connection with their job duties, then they're allowed to use them for organizing, union organizing, or protect concerted activity, right, to band together even without the union to protest their working conditions, and you don't have a say in that. Now, you probably know that the NLRB under the Trump administration changed that rule, right? It's the classic flip-flop in labor law. It drives us nuts because we have to try to give you advice on the shifting pendulum, and it drives you nuts because you just want to know what the rules are. But under the PRO Act, the rules would be set by statute, right? And so they would, under the PRO Act, it would bring back Purple Communications in full force, mandating that you allow employees to use your property, email, cell phones, et cetera, for Section 7 activity and union organizing. It would be codified into law. So much for property rights if you're an employer. Okay, and the second major bullet point on this one is a really scary thought from my perspective, and that is if you are organized and you lose an election or somehow you become organized, the obligations for newly organized employers under this law are significant. So you get the union elected. Now you have a duty to bargain. Well, now you got 90 days to cut a first deal, right? First collective bargaining agreement. So typically, if you want to keep a lot of what you have, it works for your organization, it works for your business. Union says, no, you can't get an agreement, 90 days. Then you go to mandatory arbitration. Then you go to mediation, which FMCS, the Federal Mediation Service, comes in, tries to mediate an agreement. If you can't get an agreement with the mediator, then you go to what is mandatory arbitration, and you present your case. The union and the employer present their case before an arbitrator, and the arbitrator decides. A third party decides what your contract's going to look like for at least 2 years. Okay, and look at the types of things that this third party is going to consider, right? So the union's going to give all of its ammunition on why you should pay more and agree with its proposals. The employer is going to do the same, and the arbitrator is going to weigh these factors: financial status and prospects, size and type of your operations, the employee's cost of living, the employee's ability to sustain themselves, their family's independence on existing wages, sort of more soft factors, other employers' compensation packages. So if you have a competitor down the street who is paying, wages and not making money and maybe losing money, that's going to be a factor that some third-party arbitrator is going to look at and say, well, I think if they can do it, why can't you? Well, they're losing money. Well, now a third-party arbitrator, the government imposes a contract on the employer. That's right, imposes it. I remember in current law, even if you have a union, the Supreme Court has said in multiple cases, the law has always been the government cannot require any concessions. You can't require employers to accept any terms. That's all out the window. Now the government, through this arbitration, gets to tell you what you pay your employees, gets to tell you what benefit package they get. And they get to do it. They get to do it based on all these other factors that you don't control. To me, that is super scary. So with that, I'm going to turn it back to Patrick.
Thanks, Keith. I'll talk through a few more of these changes here. And a lot of these changes kind of fit hand in glove, as you'll see. So the next one is expanding the definition of who is considered a joint employer. So again, like Keith said, we need to go back in time to talk about this, but really what this is doing is putting into a statute, codifying a decision of the Obama board on who joint employers are. So for a long time, joint employers were considered to be, employers were considered to be joint employers only if they exercised substantial, direct, and immediate control over a group of employees. If you weren't doing that, you couldn't be considered an employer of a group of employees. When President Obama took office and he appointed his board members, they changed the law in 2015 in a case called Browning Ferris Industries of California. They changed the definition of joint employer. No longer did it need to be substantial, direct, and immediate. Instead, you could have indirect control over employees and be considered an employer. You could exercise your rights over just limited and routine, exercise control over just limited and routine things, not over major components of the work they're doing, and be considered a joint employer. And in fact, you don't even need to exercise control over the employees. You just need to have the ability to do so or reserve the right to do so. So where you kept seeing this come up and it be such a big deal is in the franchisor-franchisee context. The franchisor often will have in its contract with the franchisee, we can exercise control, but they never actually would exercise it. But under the Browning Ferris standard, the Obama board standard, they would be considered joint employers. And when you're a joint employer, you can be ordered to bargain with a group of employees. You can be held both jointly and severally liable for any unfair labor practices, even if it's committed by that other employer, if you're somehow involved. And it can also subject you to picketing, strike activities that would, at least under the old law, we'll talk about that next week too, would be unlawful to picket you. Now you could be subject to that picketing lawfully, so they could place more economic pressure on you. So this would, the Trump board actually flipped it back to the old standard of substantial, direct, and immediate control. This would now take it out of the board's hands and take it off that pendulum that Keith was talking about. It would now just be the law that this is the definition of what joint employers are, and it would create a number of joint employers just based on the, sort of squishy standard that it has. So beyond that, this is another one you've probably heard about before. You might remember back in the Obama administration, the NLRB put out rules that said employers need to post this notice in their workplace, this notice being a notice of all of the employees' protected rights under the National Labor Relations Act. That was litigated, and it was determined that the NLRB exceeded its authority in doing so, so employers did not have to post that in their workplace. This now makes it law to post it in your workplace. So the unions, the lawmakers are saying, fine, the courts held that the NLRB didn't have that authority. We certainly do. We'll require this posting in the workplace. And you're required to notify the employee of the information in that posting. We don't know what that means yet. There would be regulations that come out on that. But one thing could be you pointing out the specific notice to the employee and saying, hey, here you go. This is the right to, these are your rights under the National Labor Relations Act. You have the right to form a union. You have a right to do these things. And it imposes financial penalties on employers for failing to post this notice. $500 for each violation, up to $500 for each violation, and a direction to post it. Now, what is each violation? Might they consider every day you don't have it posted a violation? We don't know that either. Certainly a type of thing that would be litigated, but there are penalties associated with it. In addition, the PRO Act would codify a rule of the NLRB related to sharing employees' personal information with their union during an election. So it would make you do it immediately within 2 days of a direction of election. You need to hand over all this information, personal home address, cell phone, landline, if anyone still has it, email address, those sorts of things to a union. And you need to do it within 2 days. Previously, you were required to do that within 5 days. They shortened it. It's been expanded back out, and there's been litigation over it. Now they're just saying we're taking this out of the court's hands again, and we're just saying this is the law. Within 2 days, you must turn this information over to unions. In addition, they're taking another piece of the Obama board and making it law, and that is micro units. So now the standard's been brought back to what it previously was. You can't have these tiny little units. If there are other employees who share a community of interest with those employees, they need to be eligible to vote in an election on whether they want to have a union because of the community of interest that those employees have. Under the Obama board, they took that away and created a standard where little tiny units within your workplace could be organized. And the only way that you could bring other employees into that group and allow them to vote is if they had an overwhelming community of interest with the employees who were seeking to vote. Otherwise, the unit would be fine, and the Obama board would let them vote. And so you ended up having tiny bargaining units. Unions could be very targeted and precise and find a group of employees, a small group of employees who wanted to organize, get an election for them. Now they have a foothold in your workplace, and now they work to expand it. Whereas if you are allowed to bring everybody in the first time, those employees might not want to be in a union, and they can keep the union out. So this would put that into law. Micro units would be okay. And the way they sort of frame it is they view employers asking other employees who share a community of interest with the group that wants a vote, wants a union, bringing those people in. They call that gerrymandering by the employer. Even though in our experience, that's not it at all. It's just they share many, many things in common with the group that wants to have a union. And so it makes sense for all of those employees to vote on it. So that would become the law now. If that were not bad enough, the other thing that happens is the employer is taken out as a party in any pre-election hearings and proceedings under the PRO Act. So the rules now is when somebody files a petition, whether to hold an initial election, to hold a decertification election, another type of election, the employer is a party to those proceedings. It is entitled to participate in any hearings that happen before the election on who is eligible to vote, when the vote will happen, how the vote will happen, things like that. Now, employers would no longer have that right, which is a pretty drastic change. And when you combine it together with the micro units, you get a situation where the union can organize a small group of employees that they know want to be represented by the union. They can then get the petition filed. If there's a hearing, the employer can no longer participate and say, okay, that's fine, but we have this other group of employees who has significant community of interest with this little group of employees who also ought to be able to vote on whether they want a union. Now it's just the union and whoever filed the petition in the hearing. And so the odds of that getting brought to the board's attention is going to be significantly reduced. And so the micro units, not only can they exist, it's going to be much, much easier for them to sail through a hearing before the NLRB. And then lastly, and this is the big one, it's a piece of the Employee Free Choice Act that has made its way into the PRO Act in a slightly different form. So it's not that you can just get a union in by showing their cards, showing you have a majority of employees who have signed union cards immediately. But what the PRO Act says is card check recognition is permitted if an election is held and the union loses, and it can be shown that the employer, any representative of the employer, violated the National Labor Relations Act or otherwise interfered with a fair election. If that happens, and if the union can show that they have a majority of the proposed bargaining unit who has signed union authorization cards, now you don't have to have another election. Instead, the board will just order you to bargain with the union and conclude that the union represents a majority of employees in that unit, and so now you have a union. So that is significant, because now if somebody commits a violation of the act or otherwise interferes with a fair election, except in the very most egregious circumstances, what the board says is, okay, let's have another election. And employees still get a chance to make a free and fair choice in that second election, removing the action that interfered with the election the first time. Everybody knows that that's the best way to determine what employees truly want, is to have a secret ballot election. And everybody also knows that people can be pressured into signing union authorization cards. People might do it because they don't understand what they're signing. They might do it to get somebody off their back who has been pressuring them for days, weeks, months to sign a union authorization card. We know that union authorization cards are not always representative of the fact that an employee wants to be represented by a union. And yet, if an action that's deemed unlawful or interferes with the election occurs, that would be what decides whether employees are represented by the union in many cases. You may think at first blush, okay, well, that kind of makes sense because the employer violated the law or interfered with a fair election. But what you need to understand is the type of things that interfere with an election can be very, very minor. So it can be something like having a policy in your handbook that we all know nobody really reads, but that the board has scrutinized and determined is overbroad. And you've heard about these before, because this is things that were happening during the Obama board, using the word confidentiality, using the words be respectful or courteous to your coworkers are deemed overbroad under certain boards. And so if you have a policy in your handbook that's telling employees they need to be respectful to their coworkers, the board could view that as overbroad, and now you've committed an unlawful act that they would say interfered with a fair election, and now you're subject to the card check provisions. But same thing for something as difficult to pin down as an implied promise made by a supervisor, right? It's not even an express promise. You vote the union out, we'll give you a raise. It's something that the NLRB determines is implied. What else could the employee conclude but that you were promising them something? And the law in this area is very sticky. It's very hard to pin down where the line is. So if you have one supervisor cross that line during an election one time, now you could be subject to the card check. Same thing with failing to timely post your notices. And what makes this so difficult is the pendulum that Keith was talking about. It can be so hard for employers and labor lawyers to determine where the line is and what is acceptable conduct, what is unlawful conduct, and it changes, seemingly with the wind based on who the board members are. So you may be thinking you're complying with the law and not interfering with an election, and the pendulum is swinging and you're on the wrong side of it, and now you have violated law without even knowing it, and you're subject to the card check provisions. So again, a very significant thing. It's not Employee Free Choice Act, but it does give the chance for card check recognition to occur. So we figure at this point, you may have heard enough. We'll give you some time to regroup, but part 2 next week, there is more bad news coming, unfortunately, your way, at least in the version of the PRO Act that has currently been introduced. Again, we don't know what will happen based on how the lawmakers sort this out and the filibuster and things like that. but we'll talk about what the other provisions in the PRO Act are. And a lot of the focus next week is going to be on the increased penalties, liabilities, fines that go to employers when they do violate the law. So part 2 will be next week. We have one question here about union avoidance training and information on that. We do have union avoidance training. We always encourage employers who have even the slightest concern about union avoidance training to engage in that, but it's going to be especially important. And so what we're doing at the end of this webinar series, we're going to talk about sort of a kit or a package that we have that can help you in the union avoidance world in the event that we need to all spring into action because the PRO Act becomes law, because so many of the tools that are currently in our toolbox at our disposal are going to be taken away from us, and employers are going to have to be much more proactive. So stay tuned on that. In the meantime, if you have questions, want to conduct union avoidance training right now, for example, please just get in touch with anyone in the Miller-Johnson Labor and Employment Group.
Just to follow up on that, right? So at the end here, we'll have a menu of options that will be available in a packet or a kit. But we do union avoidance training for lots of clients, lots of different ways. And I think it's very important that it be tailored to your specific industry, your specific type of organizational structure, and what you need. And so, I would encourage you, if you think you need this, if you think you're a target, it's better to have that training sooner rather than later. So I wouldn't want you to wait till the end of this series. If you think that's something you're interested in, reach out to me, Patrick, or if you work with another Miller-Johnson lawyer here, and we will design for you. We can lay out, have a discussion about what options we generally have, and we can design a program and train as many or as few supervisors as you want us to. So I want to make sure we're clear that don't delay until the end here. We're going to have a packet and some information to put out, but we have all that sort of ready to go in one form or another right now. So please don't delay. And there was one other question I think I want to answer before we sign off here, or two questions. One was, is this all private sector or public sector? Yes, the PRO Act does not affect public sector. Whether Michigan law will follow suit or other states' public sector labor law will follow suit, likely, but certainly the right to work changes will have overlap, that sort of thing. But what we're talking about here predominantly is private sector National Labor Relations Act covered entities. And then there was one question regarding changes on independent contractors in the joint employer rule. And the question had to do with, if you bring in temporary contractors, you bring in individuals from a staffing agency who work in a unionized environment on a temp to hire capacity, those employees would definitely be covered as employees as soon as they perform any service for you and your organization, even if they're joint employed, so they'd have those statutory rights. And the joint employer expansion makes it likely that they may become part of the bargaining unit immediately upon hire, but that will also be a function of your recognition clause or your contractual language on who's covered by and who's represented by the union. So I did want to answer that question real quick before we signed off. So unless there are other questions, or Patrick, you have anything, I just want to say thanks to everyone for attending, and we hope you can make it next week and check out last week's webinar if you missed it.
Thanks, everyone.